find something. Okay, finally, after all these technical issues, we have here Jorge Sampaio, sorry for the pronunciation of your name, who is a member of the Lisbon Public Law Research Center, the Lisbon Legal Theory Group, and then naturally the University of Lisbon. That it is today here to give a presentation about, robustly enough, a constitutivist explanation of legal normativity. Just give me a moment that I will share the presentation for you to see, and then I will give the floor to Professor Sampaio. Okay, let me just come back, circle back to this. Okay, I am not the host, so I cannot share the screen. Just wait a moment. Somebody can make me the host.
Yeah, Mila has to.
Okay. This was quite anticlimactic. Okay. Okay, I am here. Fantastic. So let me just go here. Okay. Do you see the presentation?
Yeah.
Fantastic. So I will just disconnect my.
Yes, can you hear us? Okay. So first of all, I'm really sorry for this little mess. I'm pretty sure that this was a conspiration orchestrated by Boyan. It's like clearly the best explanation for this sequence of facts that just happened. But nevertheless, I'm really it's a huge pleasure to be presenting for you guys in Belgrade. Great friends, Miodrag, Boyan, and all the others. I'm sure I will meet in some time. So, but I really like you. So this is great for me. As the title explains in a way, so I will be talking about legal normativity, and I will
Come to this position because they cannot see you because of the light for some reason.
So, and I will try to explain legal normativity through this philosophical account of constitutivism. So, very quickly, what is at stake here? When we talk about the nature of law, there are two main issues in debate. The existence of law. This is not the issue at stake here. And then there is the issue of normativity of law. And usually when we discuss normativity of law, we can ask if law is only kind of a formal standard of correction of something, for example, of our actions, or if it is something else, something more robust. It is not. It is completely natural that when we discuss the normativity of law, we also, and at least usually what is at stake is the question if there is, for example, a moral obligation to obey law, to comply with law. If there is, of course, law would have kind of an additional or a more robust normativity. So, but the question is in a way more or less related to this. So, for example, according to the Portuguese and the Serbian constitution, there is a prohibition to kill. So killing is a forbidden action. no one discusses the existence. Okay, we can discuss what are we talking about when we talk about the existence, but let's forget that now. But no one discusses the existence of a norm forbidding the act of killing in our legal systems. But the question here, the question regarding normativity of law is, are we really forbidden to kill? So why should we comply with this prohibition? Perhaps we should comply with this prohibition to avoid sanctions. So we have prudential reasons to do it. Or maybe there are moral reasons not to kill. So we are forbidden to kill, not because there are these legal prohibitions to kill, but because there are moral reasons in that sense, or regarding that. If this happens, and this happens a lot, there are prudential reasons, and usually there are moral reasons to obey at least some legal contents. Law's normativity will have some robustness, some additional robustness. But this is contingent. So this additional robustness of normativity can exist or not. There can be legal norms without sanction for their not for the actions of non-compliance, and sometimes there are legal norms that are immoral in a way. There are other legal norms that does not have anything to do with morality, with moral norms. So there are many situations in which there are no prudential reasons or moral reasons. You will see the connection, and why am I already talking here about prudential reasons and moral reasons? So disregarding these external reasons that are usually seen as providing robust reasons, normative reasons, the law would have a normativity similar to games. So without this, there is more or less these ideas such as, for example, the unambitious view of legal normativity Brian Biggs recently argued for. So law would be, in a way, only formally normative, just as a game, for example, or as etiquette rules or something like that. But my point is, this seems to me counterintuitive or in a way implausible. So my aim here is to check if law's inherent normativity is different from games. And I'm not talking about this situations in which prudential and moral reasons, they in a way give more robustness to law's normativity. I'm talking about inherent legal normativity. And I'll so in a way the point is, does legal reasons, for example, make difference in our practical deliberation, or do legal norms, for example, serve as kind of a motivational guides or that guide us? So I'll argue that there is something additional here. So there is a different inherent normativity in law that there is not in games, for example. And I will try to, or I will use a Constitutivist account to demonstrate this. Okay. So I will quickly talk about the concept of normativity. Then I will talk about this philosophical account of constitutivism, and I will relate it with the conceptual function of law. And then I will talk about the idea according to which there is a disposition to law abiding. And then I will finish with some possible objections and rebuttals to what I argued. Okay, so just to start, constitutivism is, according to Michael Smith, is the view that we can derive a substantive account of normative reasons for action from abstract premises about the nature of action and agency. But let's start with the concept of normativity. Okay, so this concept has been referred by many philosophers as a capacity of something give rise to reasons, such as canon or res. However, of course, this, in a way, already begging a bit the question, we are assuming that there are these kind of this normative phenomenon which we call reasons for action, and they are kind of a foundational normative phenomenon or concept or something like that. So, but I will. In the paper, I am finishing the paper. This part is more developed. Here I will start by just assuming this idea that normativity is explained or accounted by the power to give rise to reasons. So accordingly, law can be qualified as a normative phenomenon if and only if it is capable of providing reasons for action. And more specifically, law is presumed to be normative in the sense that legal practices constitute something capable of persuading rationally competent subjects to change their minds about doing something prohibited by mandatory legal norms governing non-official behavior, using a phrase from Kad-Ima. Okay, so I will be quick here, but the logical space of reasons is composed by epistemic and practical reasons. Here, the relevant ones are practical reasons, of course, and not the reasons, for example, to believe in some proposition. And from here, we have two different types of normativity, but again, the relevant one is practical normativity. There are also different grades of normativity, namely formal and robust normativity. And in a way, I already mentioned these two types of normativity, but I did not define them. So formal normativity presupposes the existence of a norm or standard or value, something like that, which allows evaluating some conduct, agent, event, etc., as correct or incorrect, or as good or bad. Sometimes it is also said that this normativity is conditional on participation in a certain practice. So, for example, if a legal system contains a norm forbidding killing, the act of killing, we could, if someone kills another person, his action of killing, it would be an legally incorrect action or something like that. So games, etiquette, language, fashion, or law, they all would have this type of normativity. So legal norms and these types of norms, language norms, etc., they can function as a kind of a standard to assess the correction or incorrection of actions. Robust normativity, on the other hand, implies that a certain object, for example, a conduct, a decision, etc., is right or wrong in light of a certain set of norms, but not only in the context of certain circumstances, but conclusively or all things considered. So it appears to be kind of unconditional or universal, and it applies to all human beings regardless of their will. So, for example, in a game, we can enter a game if we wish, and if we want to play the game, of course, we need to comply with the game's rules. But here, this is different. Our will does not determine our entrance in this kind of normative game. We are talking about unconditional practices or something like that. Okay. So the relevant types of reasons for constituting normativity are practical, as I already mentioned, divisible and not undivisible, and also motivating and not justificatory and objective and not subjective reasons. According again to Kenneth Ema, humans are passionately self-interested subjects, and they live in acute material scarcity, which hampers legal norms compliance. Therefore, rational, competent subjects are disposed to violate law. And this would explain why law necessarily needs a coercive apparatus to provide practical reasons capable of inducing legal compliance. I think we need coercive apparatus to in a way induce legal compliance, but I'm not sure about this extremely pessimistic view about the human nature. And I'll return to this point because this is important then for the argument I will make. So if, for example, legal systems are just, there would be moral reasons to obey them. So a legal system law, it would be not only formally normative but also robust. But this is a contingent feature of legal systems. We all know that legal systems can be wicked. Okay, so the question is, are humans really inclined to do these things prohibited by law? Are we disposed to disobey for example, the legal imposing rule to stop in a red light? Okay, so now enters the Constitutivism as a way to trying to show that there is something else in law's normativity. So, first of all, law can be viewed as an artifact designed to achieve the purpose of governing human behavior through legal norms for solving practical uncertainty. And it is possible to ground law's normative features would it be possible to ground law's normative features in an account of its function? Again, this would be the use of a constitutivist account for explaining normativity, to try to ground law's normative features and law's function. Right, so insofar as law's conceptual function is normative governance, any legal institution, to be a legal institution, would be in a way obligated to engage in normative governance. If this is true, the question we need to pose is, are we rationally committed to entering legal activity in a way we are not regarding, for example, games? The existence of law simultaneously presupposes agency and purports to domesticate practical reasoning, which immediately differentiates it from games. But is that all? Okay, so constitutivism seems to be connected to the explanation of normative facts. For example, we have reasons to perform certain actions. Certain outcomes of actions are better than others. Certain people are virtuous, whereas others are vicious, and so on. For constitutivists, the constitutive features of something, for example, the features in virtue of which that thing is the kind of thing it is, such as the constitutive features of some person, action, state of affairs, etc. They would explain the normative facts about that thing. These constitutive features being more fundamental, they would entail some normative claims about all those things, and legal norms would be no exception. And the main advantage of an account like this is that from factual premises, it seems that we could achieve some normative conclusions without violating Hume's guillotine. Right, so for example, if the function of law is to govern behavior, and the legal norm is unable to do it, one can express the following normative judgment, which is legal norm 1 is a defective legal norm, or perhaps it is not at all a legal norm. Okay. According to a not too committing constitutivist account, requirements of practical rationality, they can be derived from constitutive features of agency. Action in a minimalist account, purports to change the world so that it conforms to our desires. So I desire an X. I see that I could achieve X by doing Y. So I do Y. From here, one can deduce the instrumentality principle, the rationality principle, or the principle of instrumental rationality, which tell us to choose necessary means to our ends. So, if law is a means to one of our ends, for example, an end that we desire, then we should regard law, qua legal norms, as an objective matter of normative practical rationality, as a standard to be complied with. And this would explain the intuition legal claims have some authority over us, which does not happen with games. Additionally, I think that as a descriptive matter of contingent fact, people are actually disposed to follow legal norms. Of course, they have other dispositions, for example, to violate norms in some situations, and they do not comply with legal norms in many legal situations, but I will try to, or at least I will give an explanation of this. All right, so now let's go to the third part of my presentation, which is related to the idea that there is a law compliance attitude, and this immediately shows that law's normativity is much more than a game's normativity. Okay, so it seems undisputable that law as a normative system, it aims to guide human behavior. Therefore, even if law as an artifact may have other uses, there seems to be agreement that law has the constitutive function of normative governance. However, artifacts, they are used in a characteristically way to solve some basic problem people want to solve, or at least this is one way to try to identify the constitutive function of something. And normative governance per se does not seem the problem to solve. Regulating behavior is not something we seem to value for its own sake. It seems that we regulate behavior for something else. So what is the foundational problem that law is needed to solve? In constitutive terms, what is the ultimate end law as a means is used to pursue? So there are several ultimate ends for which legal systems are used to govern the behavior of human subjects. For example, some philosophers argue that law is used to morally justify the use of the state's police power, to tell human subjects they should do according to the right reason in a manner that makes them more prone to conform their behavior with right reason. This is, of course, Ra's thesis. To settle disputes about what morality requires, to specify objective moral requirements, to keep the peace among human subjects. This is one of the last conceptual functions imputed to law, and it is defended by him. But I think a less committing claim is that law is functionally contrived to and used to cooperate to survive. I think, for example, in comparison with the function to keep the peace among human subjects, which is in a way based, as I already mentioned, in a too pessimistic and probably false idea of about the human nature, about human persons, and the idea that we use law to cooperate to survive. It seems to be in a way more coherent with the data coming from, for example, it's difficult. I'm always trying to remember the words in English and translate it. So yeah, empirical research, for example, related to the theory of evolution, they seem to, in a way, to show this, that we, of course, we are not completely rational in complying with law, but usually there is something there, and the idea, the Obesian idea that we are amazingly bad and wanting to go to war and stuff like that, and without a coercion, it would be impossible to have societies. It seems to probably false, and it's an extreme view about the human nature. Okay, so but for the instrumentality principle, I was referring before, to be instantiated, law must be an essential means for the end of cooperation to survive. Of course, if we can, in a way, pursue cooperation for survival without law, for example, just by using morality, all this idea would be false in a way, because law, it would not be an essential means for the end of cooperation to survive. But I think there is something here, because again, and in comparison with the actual function of keeping the peace, sometimes for cooperating to survival, we make war. So the function to keeping peace, it can be an instance of cooperation to survival, but we can do war for cooperation to survival. Additionally, if we compare law, for example, to morality, it has a scope much more restricted than law. Morality only applies to some specific areas of life. Law, in a way, it seems to it can encompass all areas of life, everything, being moral areas, aspects of life, morally relevant or not. In addition, sometimes there are moral disagreements, and law is even used to solve, at least from the practical point of view, to solve those disagreements and to allow us to live in society. Okay, so evolutionary psychologists, they claim that a significant portion of the psychological mechanisms governing human behavior, they are biological dispositions that develop through natural selection in response to the conditions in the environment of our ancient Stone Age ancestors. And these psychological mechanisms, they underlie contemporary human behavior, that underlie contemporary human behavior. They were favored by evolution because individuals possessing these mechanisms, they had an enhanced likelihood to survive in that environment, and consequently, they had a greater probability of transmitting their genetic traits to the next generation. It is well known that humans are social species, and that relies on cooperation to survive and thrive. So according to these evolutionary psychologists, human psychology has changed over time in ways that support larger, more cooperative societies that characterize modern humans. So cooperation is one of the most important ends human beings value, and law is one of the paradigmatic means they created to cooperate. For example, when art was analyzing the necessary conditions of law's effectiveness, he expressly acknowledged that survival is an end of humans, when he claimed that an overwhelming majority of men wish to live even at the cost of hideous misery. Again, the idea that we are disposed to survival, and we can even do things to survive at the cost of hideous misery, for example, war. Additionally, for example, ethicists such as Alan Gieber, they also argue that the normative judgmental capacity humans have, it may be explained in terms of its contribution to coordination, it's true that he talks about coordination and not cooperation. Coordination is a more specific hand, but it is also an instance of cooperation, which is kind of a biologically function selected by evolution. So in a nutshell, evolution seems to have disposed humans to cooperate. And since law is a paradigmatic form of cooperation, it is fair to infer that human beings are disposed to create and obey law. And I already, in a way, compared, and I also have that notes here, but I already compared the law with morality. Okay, but so the conclusion is, according to evolutionary theory, humans are disposed to cooperate to survive, and the desire to survive is therefore a constitutive aim of human beings. And as law is a means to this, and we are rationally committed to follow legal norms. So it's curious because we are, in a way, from the rationality point of view, we should follow law, and at the same time, it seems that as a matter of contingent fact, we are disposed to do that. So an important question here is, of course, law is to question if law is an essential means to cooperation to survival, as I already stressed. To put it differently, is normative governance essential to survival, or can it be achieved in a lawless, anarchist society, or, for example, through morality? On the one hand, I think morality does not seem a substitute for law in pursuing the end of cooperation to survival, due to the two reasons I already mentioned: the more restricted material scope of morality, and the fact that morality many times gives rise to disagreements law than is used to solve. On the other hand, for example, practical deliberations done by casuistic weighting seem to amplify risks and disagreements. And I think the exclusionary nature of law's functioning seems precisely to diminish risk and to solve possible disagreements. So it's the idea of a possible society like anarchist society. It seems to be it seems to be probably false or impossible to exist. Okay, so I only have 2 minutes. I will try to.
If you want like a Q&A.
Okay, yeah. All right, so no, okay. So the point here is I'm arguing that we are hardwired to cooperate to survive. The essentiality of law is such that human beings seem to have developed this disposition to abide to law. We have. I argue we have a law-abiding attitude. This attitude is it has different elements. The relevant one is the cognitive element, which is precisely the disposition to comply with legal systems, and more specifically to follow legal norms. So I'll try to very quickly just to explain this last point. And then we can discuss it in Q&A the rest, and then some questions I already have here, like anticipated. Okay, so this law-abiding attitude, it gives motivational force to legal reasons, and consequently, legal reasons, they are not merely inert formal reasons. So in assessing what we ought to do as a matter of contingent fact, we are supposed to follow legal norms. But note that the existence of this attitude and its force is independent of the existence of reasons for action. And this disposition means that people show an increased degree of resistance to reasons against compliance, but they are, of course, not indefeasible. Actually, whenever people feel legal norms are stupid or immoral, other attitudes enter at stage. So this explains the need to provide legal systems with coercive apparatus, such as civil and criminal sanctions. Law enforcement has the capacity to generate prudential reasons, which are a necessary condition for the general effectiveness of legal systems. But it also explains the fact that legal systems seen by people as morally illegitimate tend over time to lead to non-compliance and even to revolutions. Nevertheless, the point is that if it is true that we develop through evolution this law-abiding attitude, rational, competent subjects will have as a descriptive matter of contingent fact this law-abiding disposition, and because law is an essential means to further the end of cooperation survival, those subjects should have as an objective matter of normative practical rationality a law-abiding disposition. Just to finish in a word, of course, one of the possible objection it would be, okay, but is there any empirical evidence that we are disposed to comply with? Actually, there is. I will just mention that there is a book from Tom Tyler in which he gives many empirical evidence that people are, in a way, disposed to that. But there are other, and I will finish, there are other studies. For example, remember the intuition of Hannah Arendt, in banality of evil. And there was, for example, Milgram's experiments that showed that when an authority, a legal authority, for example, actually it was a more broad one. Whenever there is an authority, there is kind of people tend to comply with. But there are some evidence showing this. So, for example, Schauer is quite critical about this idea that people are supposed to comply with law, at least if there are no sanctions. But I think is incurring in a fallacy of generalization. Okay, so thank you very much.
It just puts.
Oh yeah. So yes.
Yep. So, okay, now that like the presentation has come to an end, I will open the floor to questions. I see one question in the chat. Okay, 3 questions. So going in order, Bojan.
Nice to see you, dear Sampaio. Thank you for the great presentation, and I'm sorry about the problems connecting. I'll try to be short as I'm exercising being short in questions. It was a very interesting presentation. So, and this topic of the function of law, or the proper conceptual function of law, I find it very interesting. But unfortunately, I kind of find it a bit confusing, and I don't think we've done much with this artifact theory of law and trying to ascribe a proper function to law. Now, what my problem is, and maybe I'll need a conceptual clarification on this. When you say, for example, you or the literature, the conceptual function of law, do you consider it to be the function that law has distinctly from other things, for example? So that's my first question. So is it the function that the law has compared to other, let's say, things, or other similar things?
Right. So,
like for example, morality. And just the second question, very shortly. Now, what I think is and I might be wrong on this, the problem with the argument is it sounds compelling, but this is the usual problem when we discuss these functions of law. We usually tend, and the literature on artifacts, for example, tends to discuss morality and law, while completely or partially absent is the discussion, for example, of the relation between the system of social norms that are not law. And this is basically my second question. It seems to me that that we would do fine, or at least we would be able to survive if we only had social norms without having law, because many social norms exhibit the same properties that law exhibits. Some of them are coercive, they have adequate reaction, they are more precise than rules of morality, for example, and so on and so on. Let's take the queuing norm as an example that's usually not regulated by law, and arguably it's not a moral norm. So that would be it. Thank you.
Well, the two great questions, of course, Boyan. Thank you very much. So regarding the first question, which is a conceptual clarification about what is a function for me. So of course there is some overlapping between law's function and morality's function. Some think that law only regulates human behavior. Of course, law also, for example, constitutes institutional behavior, but it would be only related to behavior, that is action, and morality, at least for some, regulates both human action, and also human attitudes. But when I'm talking about function, I'm talking about and I will explain it in two or using two things. First, for me, when I talk about a function or an artifact function, when I'm talking about law as an artifact, is just the intended purpose of and for which it was designed, built, or at least implemented or preserved by, for example, a group of agents. It's just this. And for a function to be not an accidental, but a conceptual function, the idea it would be that all instances would need to have that function. So the ideas are this, more or less this. Your second question is really interesting, because I focused more in trying to show that law is essential to cooperation to survival in relation to morality, but less in relation to what you call social norms. What I'm not sure, and I need to think more on that, but what I'm not sure is that when we talk about social norms, which are not, for example, etiquette norms or stuff like that, they are not actually legal norms, because these social norms, they seem to be customary norms, and customary norms are legal norms. So there is here something, and I need to think better on that, because it's really important to for the as you claimed, and I know that. So for my argument to be convincing, I need to show that law is an essential means to cooperation for survival. If there is an alternative means that without law we can do the job, so my argument in a way loses its plausibility. I'm confident about in comparison with morality, but with social norms, I haven't think about that, even if my intuition is this one.
Well, thank you very much. For time constraints, I think that we will accumulate the questions and then give the floor to Sampaio to answer all the questions, or whatever questions he can answer. So first, Amin, so sorry for the pronunciation of your name. Hope it was all right.
Yes, no, that was perfect. Thank you. Thank you so much for the paper. I really enjoyed it. I am in your camp in my intuitions, but I'm not convinced that even if I bought the function of law as coordination or as anything like that it would be anything like robust normativity. The thing is, like, if you look at David Enoch's work who attacks the idea that law has robust normativity, he will totally grant you that law may have this sort of function. And many legal positivists have argued no less, right? Except that they will say that these are triggered reasons. Like basketball is a fun game, and the reason you have to play it is that it's fun. And if it wasn't fun, then you wouldn't. And law can help you coordinate. And that's maybe why you should do it. And, you know, they can totally accommodate that. So how do you get more than a merely triggering or a merely formal normative? Right? The idea that law is formal, in other words, doesn't mean that it will never give you reason. It will just give you the sort of reasons that any other phenomenon could give. And so David Enoch again makes the example of the weather. It's raining, therefore you have reason to take an umbrella. That's a real reason for action that you have now in light of the weather. But the weather is no more normative than anything, right? It's not at all similar to morality or anything like that. So I would just wanted to either address it today if there's time, or in writing, and we can also address.
Okay.
We are going to accumulate because of the time. So sorry.
Okay.
Joao? Message?
Oh, yeah.
I'm so sorry. Okay, so Pedro?
Can you hear me? Yes. It's similar to Boyan's question. It's about this. So function. It seemed to me that function in your presentation is ambiguous between two things. So now it's more clear to me that the concept that you have in mind is function as maybe one of essential or contingent element of the concept of law. But you might use, and maybe you should use another concept of function that's very important to explain the structure of concepts, for example, the concept of law. And in this case, this notion is a mathematical function. So you have inputs and outcomes, and this is a mathematical or instrumental or syntactic function that help you to explain how you can pass from input to output. So this maybe is useful to explain the structure of abstract concepts, for example, law, morality, etc. And maybe these two different concepts are in your view about the concept of law and the role that normativity plays there. And yeah, I have many other questions, but we can talk after the talk. Thank you.
Okay, so now I see that Gonzalo also wants to ask something. So please go.
Okay, thank you. It's a really quick question. I was wondering, when you were talking about the function of law, if that comes associated with the conception of law as a coordination convention or not, and what's your take on it?
Okay, so we also have what? Something is open. So we also have some questions in the chat by Joao, but I think that you can answer, and then you can consider the questions in the chat.
Okay, so first, Amin's question, which is
Pedro, if somebody from the
which is of course really interesting, and David Enoch's account of legal normativity is one of the main ones, and an interesting one. Of course, there was lots of things I in a way just assumed, because it would be impossible to talk about, but and for example, actually there is an important objection of David Enoch, not to what I'm saying about legal normativity, but regarding constitutivist accounts. But I will skip that. Here, okay. So I see the thing. What I am trying to do is to check if is whether there is anything else than this formal normativity that everyone agrees that law have just as a game have, and then the kind of enhanced normativity that, for example, morality or prudence gives to law. So is there anything else? Because if there isn't, maybe that's what that's reality. So law without its coherence with morality and without a coercive apparatus is equal at the normativity point of view to a game. But this seems to me that it would be an amazing conclusion. So I was trying to see if there is something, even if the robustness of legal normativity would not be similar, for example, to this robustness that David Enoch is talking about. He is a non-naturalist realist at the ethics point of view. So he thinks that normativity is a property represented by our, for example, talk and thought. I'm far from that. I do not want to commit with all those strong things at the meta-normative point of view. I am in a way trying to say at the conceptual point of view, in a perspective that more or less everyone would agree, for example, be they realists or anti-realists at the meta-normative point of view. So I'm trying to stay at that point and try to check if there is something that in a way boosts legal normativity without morality and without prudence, which makes it different from a game. And probably, I think in a paper, of course, this is already more clear. What it seems to me, if this disposition to comply with law, it exists, if this claim is true and its connection to a cooperation survival, to the theory of evolution, it seems that from the motivational point of view, there is something that differs law from a game. So the law's perspective, using an expression of Stephen Finlay's, it would be a relevantly motivated perspective, because we desire, even if we are not aware of that, we desire to cooperate to survive, and we use law as a means to that. So this normativity would be in a way more strong than what exists and for example an account such as Anna. For example, just to show that there is, of course, a difference, and I'm fully aware that what I am arguing is different from a realist, mathematical realist such as Enoch argues. For example, Derek Parfit, quoting Stephen Darwall, he argues that for the philosophical naturalists concerned to place normativity within the natural order, there is nothing plausible for normative force other than motivational force. And I think in a way, at least we have this, and I'm trying to show that law has this additional motivational force. I think this is already something. But David Enoch, Derek Parfit, these ethicists that are realists at the morality from the meta-ethical point of view, they are talking about a different thing. They think that robust normativity is more than this. So maybe this is kind of a, if I'm not, I think that David Enoch, he qualifies this Constitutivist account as kind of a quasi, it's like a medium term between these types of accounts. So, but my point is, I understand all that. I'm from a perspective different from David Enoch. I don't want to commit to more realism. And I'm just trying to see if there is something non-contingent, at least for the humans as they are in our world, that enhances, that gives more robustness to law's normativity. And from that point of view, law's normativity, legal normativity would be different from a game's normativity. Of course, all the other things you mentioned, I agree with that. Morality can give more robustness to legal reasons, and prudence also. But okay, so I hope I answered your question. I mean, so Pedro, okay, so a different concept of function. Yeah, I have to think about it. So I try to use a concept of function which is more or less used like generally in artifacts theory, which is, as I mentioned before, is just the and constitutive and which is present in all instances of that entity. Just that, but this can be maybe this account is false or is wrong or something like that, and I need to think a bit more about that. It looks interesting, and we'll keep the discussion after. All right, so Gonçalo. Okay, so the function of law as a coordinative convention. So when Gerald Pistam and then also Jules Coleman, they use the concept of coordinative convention to, in a way, explain something here. They then precised it, and they told that they were talking about only the rule of recognition. Only the rule of recognition would be a coordinative convention. Even this, of course, is debatable, and I'm far from. I think the function of the rule of recognition is constitutive and not coordinative, but okay, that's a different question. One thing that is important on your question, I'm talking about, it's like the function I'm like ascribing to law is more broad than coordination. So cooperation, at least it seems to me, and I'm thinking on a concept like that, is it can be instantiated, for example, by coordination, but there are other forms of instantiating cooperation different from coordination. Coordination is a more restricted or narrow scoped concept. So I'm talking about a function more broad. What is the good thing here? It's even if this is still not a formal function, but already kind of a substantive function of law, because it is very broad, and it is probable that all instances of law show it. So it is easier to get agreement with everyone on that. If I were talking only about coordination, probably like the majority of people would reject my claim. That's more or less my idea.
Okay, I think that he was very exhaustive in his responses, and okay, you have these Joao questions, but he's not here anymore, so you can just take them for your research.
Yeah. Yes. Then I can discuss with Joao.
Yes, absolutely. So, well, thank you very much, Sampaio, for this fantastic presentation, and we are sorry for all the technical issues that were going on.
No, it was my fault. I'm so tired. So my daughter didn't sleep last night. Then I hit my head in her bed. So I'm here to, I'm only here for my Belgrade friends.
For you guys.
Yeah.
Well, thank you very much again with these circumstances. And see you then next week. I think that we have David Duarte next week.
Yes.
For another presentation of a member of the Lisbon Legal Theory Group, Lisbon Public Law Center, etc. Bye.
Thanks, Sampaio.